Je vois le nombre de participants qui augmente et donc je vais laisser le temps à chacune et à chacun de nous rejoindre tranquillement avant de lancer les débats. J'en profite aussi pour vous remercier très chaleureusement parce que nos webinaires de décryptage des rendez-vous internationaux sont toujours particulièrement suivis et ça fait évidemment plaisir de savoir que ces moments-là sont utiles pour vous. For English speakers, welcome. We'll start in a minute. I remind you that there is a simultaneous translation and that the relevant information to use it is included in the chat. Le nombre de participants continue d'augmenter, donc j'attends encore quelques secondes. Ok, je vous propose donc de démarrer ce webinaire. Bienvenue à tout le monde. Un webinaire consacré, vous le savez, au traité haute mer qui a été adopté il y a quelques jours après de très longues années de négociations. Alors après cette adoption, il y a eu évidemment un moment de célébration tout à fait légitime et vient maintenant le temps de l'analyse et c'est ce que nous allons vous proposer durant ce webinaire. Mais avant de nous plonger dans le texte, je souhaiterais d'abord donner la parole à Florent Merle de l'Office français de la biodiversité pour quelques mots introductifs. Florent, la parole est à toi.
Merci beaucoup, Julien, pour ces mots et merci de me faire l'honneur d'ouvrir ce webinaire. Bonsoir à toutes et tous, bonsoir aux organisateurs, aux orateurs, invités et participants. Je tiens tout d'abord à remercier très chaleureusement l'IDDRI, qui, aux côtés de l'Office français de la biodiversité que je représente, a œuvré à la prompte organisation de ce webinaire. Vous l'avez noté, cette analyse vous est livrée 10 jours après la clôture de la conférence à l'ONU à New York le 4 mars dernier. Merci ensuite aux conférenciers, Arne Langlet, Claudia Kremers, Glenn Wright, Harriet Arden-Davis, qui apporteront leur regard d'experts dans ce webinaire, consacré, vous l'avez compris, au nouveau traité sur la biodiversité en haute mer, dit BBNJ, comme Biodiversity Beyond National Jurisdiction, ou encore en français dans le texte, le traité sur la conservation et l'utilisation durable de la biodiversité dans les zones ne relevant pas de la juridiction nationale. Le navire a atteint le rivage. C'est ainsi, avec cette belle métaphore, que Renali, la présidente de la conférence, a clôturé la 5e et ultime session de négociation après 2 semaines de négociations éprouvantes. En dehors des applaudissements émus des délégués, et qu'on vient de noter que c'est l'ensemble de la communauté internationale, des gouvernements et du monde scientifique autour des océans, ainsi que des ONG qui qualifient unanimement cet accord d'historique. Alors pourquoi autant d'enthousiasme? D'abord, point numéro 1, on se réjouit parce que c'est l'aboutissement d'un long processus multilatéral, comme il n'y en a plus beaucoup, qui est enclenché depuis 15 ans et qui met en place un outil juridiquement contraignant et engageant pour les États. Deuxième point, et surtout parce que c'est un traité qui va être une pièce essentielle dans le puzzle de la conservation des océans, lequel souffrait jusqu'alors d'un cadre réglementaire extrêmement incomplet. En effet, au-delà des zones sous juridiction nationale, autrement dit les zones économiques exclusives, jusqu'à 200 000 des côtes, il n'y avait pas d'autre cadre que celui de la Convention des Nations Unies sur le droit de la mer en 1982 et quelques accords spécifiques sur la pêche et l'exploitation minière dans les hauts fonds pour encadrer la conservation des océans. Il faut savoir que les zones en haute mer représentent 64% de la surface totale des océans et 90% de sa biomasse. Enfin, troisième point, parce qu'il permettra d'être un outil très concret au service d'un autre accord multilatéral sur la biodiversité, qui a été conclu là aussi très récemment. C'est totalement exceptionnel. Donc, c'est l'accord sur le cadre mondial post-2020 sur la biodiversité qui a été validé en décembre dernier à Montréal et qui, lui, fixe une cible de protection de 30% des mers d'ici 2030. Alors, quels sont les objectifs et les mesures principales de mise en œuvre de ce traité? En résumé, le traité a trois grands objectifs et 4 mesures de mise en œuvre. En termes d'objectifs, il s'agit de renforcer la gouvernance en haute mer, de mettre en œuvre des instruments de protection effective de l'océan et de la biodiversité marine, et enfin, lorsqu'il y a exploitation, une utilisation durable de ces ressources. En termes de mesures de mise en œuvre, celles qu'on va détailler aujourd'hui dans ce webinaire, on en a 4. C'est d'abord la création d'outils de gestion par zone, qui permettra in fine la création d'aires marines protégées. Ensuite, l'usage des ressources génétiques marines et le partage des avantages qui en sont issus. Ensuite, les études d'impact environnemental pour assurer une utilisation durable. Et enfin, le renforcement des capacités et le transfert des technologies. Voilà, je vous remercie de votre écoute. Je passe maintenant la main aux experts et je vous souhaite à toutes et tous un excellent webinaire et des échanges fructueux. Merci.
Merci à toi, Florent, et merci à l'Office français de la biodiversité pour le soutien constant apporté à l'IDRI depuis de nombreuses années. Alors, je vous propose maintenant d'entrer dans le vif du sujet. On va revenir avec nos experts sur chacun des 4 éléments constitutifs du traité. Nous commencerons avec Arne Langlais de l'Université de Vienne et membre du fameux projet Maripol Data, qui traitera de la partie ressources génétiques marines. Nous poursuivrons ensuite avec Claudia Kremers de l'IDRI sur les outils de gestion par zone, y compris les aires marines protégées. Glenn Wright de l'IDRI fera ensuite un focus sur les études d'impact environnemental et Harriet Arden-Davis du programme Ocean Voices nous parlera renforcement des capacités et transfert de technologie. Alors, chacun de ces éléments mériterait évidemment des heures de discussion, mais l'objectif ici, c'est avant tout de vous donner une première analyse du texte, et donc ça sera donc assez rapide. Les interventions seront assez concises, mais vous aurez quand même la possibilité de poser vos questions à nos experts à travers la box questions-réponses, et je vous invite déjà à poster vos messages et questions si vous le souhaitez. Peut-être une dernière information avant de laisser la parole. Dans ce programme, il manque évidemment une partie consacrée exclusivement aux arrangements institutionnels nés du traité, parce qu'ils sont extrêmement importants, mais ça nous semblait un peu trop ambitieux de l'ajouter au programme, vu le temps réduit pour ce webinaire. Néanmoins, nos experts incluront certains développements à ce sujet, et vous pourrez aussi, évidemment, vous êtes libre de leur poser vos questions sur ce thème également. Voilà, vous savez tout, je donne maintenant la parole à Arne pour une analyse de la partie consacrée aux ressources marines génétiques, en vous invitant d'ores et déjà, si vous souhaitez, à poser vos questions dans la box prévue à cet effet. Arne, the floor is yours.
Hello, everybody. Thanks for tuning in. Can you just a quick signal if you can see my slides? Perfect. Okay. Yeah, thank you very much for inviting me. Thank you, IDDRI, for organizing this, I think, very useful seminar to explain a bit or communicate a bit the outcomes of the BBNJ Treaty. My name is Arne Langlet. I'm working at the University of Vienna for the ERC project Maripol Data. And I will talk a bit about the first package item, that is marine genetic resources, or as I will mainly say from now on, MGRs. This is the abbreviation that has mainly been used. So just very quickly, what are MGRs? In the treaty itself, it's defined as any material of marine plant, animal, microbial, or other origin containing functional units of heredity. You can see on the left, for example, a picture of a deep sea sponge, and any DNA sequence or any genetic information of the sponge that is used could be an MGR, for example. Why is this so important, and also why is maybe economically and politically important and was such a difficult issue for such a long time? It's used in pharmaceutics, cosmetics, biotechnology, and other sectors as well. And it could have or has, to some extent, already significant economic value. And this treaty now had the goal to ensure a fair and equitable sharing of benefits arising from activities with respect to marine genetic resources and digital secrets information. And I highlight this here because it was a big discussion under the Convention of Biological Diversity and the CBD. And there are some interlinkages between these two organs. So the question now is, how will this treaty achieve this goal to ensure this fair and equitable sharing? And this is what I will explain in the next slides, some key provisions and also the system that this treaty aims to establish. And then in the end, I will give a little assessment and also my assessment, and I will give the main takeaways already here. I think it's a very flexible mechanism. And I think what needs to be highlighted most is that all the benefits, the monetary benefits from this mechanism will flow to conservation projects, will flow to the implementation of this treaty. So I think this is really important. But let's jump into the text. So here are some key provisions on MGRs. The system it aims to establish is that it will have obligations for notifications, pre and post cruise notification for researchers that conduct such sampling in areas beyond national jurisdiction. They are required also to have a data management plan. And then this is new, to have a BBNJ standardized badge identifier that will be tagged to each of the samples that stem from these international waters. Then researchers are required to upload all the data on open access databases. And then in the end of the process, the results of utilization, and there should be a notification on the results that mainly center around the 3 Ps, the publications, patents, and products. So I highlighted here in orange that yes, there will be some obligations for researchers and companies to adhere to this notification scheme. But in green, this largely takes into account already existing international research practice. So for most projects, there shouldn't be much of an additional burden. Only the BBNJ and batch identifier is really new. And then the second part of the system is about the benefit sharing. And there are 2 tiers. This is mainly the non-monetary and the monetary benefit sharing. The non-monetary benefit sharing in Article 11.2 foresees that there will be access to samples, collections, and digital sequence databases. So in essence, to all the data and all the samples that are around this string of research, this MGR research. And this should allow the participation of developing countries' researchers in research cruises, but also in the research projects and the analysis later on, and also in the development of products, hopefully. So these are non-monetary benefits. On the other side, there are monetary benefits to be shared. And this is, I think, the big news of this, this treaty is that states agreed that there will be monetary benefits to be shared. And these should be shared in two different forms. So first, there will be a decoupled fee that only development states pay to a special fund, which should be then later on replaced by payments that are directly linked to commercialization. So some sort of a fee upon commercialization of products. But these details need to be need to be designed in the next years. Important here, again, all this money goes to conservation and capacity building for the implementation of the BBNJ treaty. So there's no direct payments to state. And this new mechanism, this new modality that shall be developed within the BBNJ treaty to ensure the sharing of monetary benefits has also the capacity to take into account the Convention on Biological Diversity, the CBD decision on DSI. So there's also they also aim to establish a mechanism for sharing of benefits from DSI, and these should be harmonized at some point. I think then, how should this work in as a system? We can maybe go through this, and I here take any state party, for example, France, maybe in this case, that will hopefully become a member or a party to the BBNJ treaty. So the state party will create national legislation. So these provisions that I just presented will turn into national legislation, upon which researchers and companies, for example, Tara Ocean in France, will have to adhere to this legislation. So they will have to comply with the monitoring or with the notification and reporting scheme. They will notify and report to the clearinghouse mechanism, which is part of the BBNJ framework. This is an institution that will be set up under the BBNJ that will not function only for MGRs, but also for the other packages. And the function of this institution is somehow to have some sort of a data center for the treaty. This clearinghouse mechanism will deliver information to the Access and Benefit Sharing Committee, which will develop the new guidelines how monetary benefits should be shared. And in doing so, it should take into account modalities under the CBD, which simultaneously establishes a system for the sharing of benefits from DSI. And hopefully these will harmonize at some point. This report that this committee produces will be sent to the state parties so they can comment on it, but vice versa, the same happens. So state parties also need to report to this committee how they implement this legislation. And this report then goes to the COP, the Conference of the Parties, which is the main decision-making body of BBNJ. And there, France or all other state parties are a party in this COP. They have a voting right. And there, this COP, with a 3/4 majority, will adopt, hopefully, new benefit-sharing obligations, which then are compulsory for the states to adhere to and to implement, basically. And then the monetary benefits that states will have to pay will go to this special fund that is under Article 52 of the treaty. And as I said before, this has a very specific purpose, this special fund. Okay, so overall, my assessment here, I think that this treaty had a very specific task and did a very good job in balancing two different sorts of interests. So on the one hand, there is the guarantee that there will be benefit sharing that mainly consists of access, so pre and post-cruise notifications ensure access for researchers from developing countries, participation through these reports, also access and participation in accessing the data, the databases, there will be open access, and monetary benefits that should be related to commercialization. And I think this was very important for the G77, so for the group of developing states, that there's not a handout, some sort of a developing money giveaway, but a right to a commercially oriented fee, so really tied to the commercialization. On the other hand, there will be some notification and reporting burden, but this should be kept to a relative minimum, as almost all of the provisions represent common international research practice and standards. And here, the EU and like-minded countries wanted really to avoid a burdensome track and trace mechanism that really goes through the process of research and tracks the sample and the subsequent sequences through each step of the research process. And so here we have now a system that focuses, that gives access to the samples and to the data, and focuses then on the outcome, the PPP, the products, patents, and publications, in ensuring the benefit sharing. And I think so overall, I highlighted here in green, this has quite a nice balance. Again, as I said a couple of times now, on the plus side, all monetary benefits are used for the implementation of the treaty. There's no direct payment to any states. So the money goes to a good cause in that sense. Maybe as a question mark here on the right side as a minus, I think it remains to be seen how nationally operating companies can be included in this scheme, and where they have to provide data and so forth. There are many where practical in the text, so there may be some loopholes here for companies that really don't want to adhere. And I think the committee that develops, the Access and Benefit Sharing Committee that develops the new guidelines, could think a bit more about how maybe also providing positive incentives for contributors of data and so forth, and for good cooperative research practices to maybe benefit from the system as well. Then also, I think flexible, I think the system has the chance to include the decisions under the CBD. And if there is a multilateral harmonized benefit sharing system for DSI, then this can become maybe to some extent also part of the BBNJ system. And that would be really, for I think everyone, would be really a useful step. On the other hand, I think, and I think this is what we've seen in the CBD and also in BBNJ, this issue is very political. The issue of benefit sharing from DSI, so from data, from genetic data, is very political, has been discussed in CBD for 20 years and BBNJ as well for many years. So this will likely also politicize the COP decisions and the COP negotiations. So the political debate will not be over, and it's going to continue. Yep. And I think these are my overall assessments here in the beginning. And I think it has a lot of potential, and I'm looking forward to your questions. And thank you for listening. Thank you very much.
Thank you very much, Arne, for your analysis. Let me report back some questions we received in the chat. First, do we have any idea of the size and importance of the bioprospecting sectors in the ICs? Do we have any figures on the markets that it represents?
Yeah, it's a good question. And this is also, I think, that there is such a question is the reason why there is a EU grant to conduct such a study to estimate these values. So there is no clear number. The bioprospecting sector is significant. And there is a study conducted by a private market research institute that estimates it around 6 billion per year. And this is a very significant number worldwide. But there is no distinction in this study or in other similar studies up to date between the high seas and national waters. So it's very hard to estimate how much is in the high seas actually. But as I said, there is, while I'm speaking, there is a big study group conducting a study to estimate exactly these numbers and also differentiate between high seas and national waters.
Okay. Thank you. A few questions about implementation and enforcement. Basically, considering how easy illegal activities are in the high seas, who is going to monitor genetic collection activities and enforce the agreement? How do you think we will know if a researcher goes out to ABNG and collect MGRs, but does not submit any notifications to the clearinghouse mechanism? So, yeah, your thoughts on the implementation perspectives.
Yes, that's a very good question. Also, always anything related to the high seas has an enforcement issue, at least. I think from the research perspective, we can expect enforcement because, as I said, it really promotes the best scientific practices. So all publicly funded research projects, at least in the EU and in many other states, operate in a manner that is very similar to what is here. So they will, because it's what they've been doing mainly. Where applicable as practicable, and there is always some.
We are losing you.
How
We lost you, Arne. Yeah, I think that we lost you. So let's move to, we will go back to the questions to Arne because there are plenty of other questions. Let's move maybe to Claudia for another part of the treaty, which is dedicated to area-based management tools, including marine protected areas. So Claudia, please, and then we go back maybe for a few questions to Arne.
Okay. Thank you, Julien, and good morning, good afternoon, and good evening, everyone. So the BBNJ Treaty finally creates a global mechanism to establish marine protected areas, as well as other area-based management tools in the high seas. I will tell you a bit more about the process to create area-based management tools and some of the implementation challenges that we've already identified. So first of all, we would like to start by providing you a bit of a broad overview of the process. So I'll go into the details later, but you can already see that there's three components. So there's the development of the proposal, where different stakeholders will be invited to also provide their opinion in the development of the proposal. And then we have the consultation process and the decision-making process. So eventually you have to think about it in a way that the proposal will be ping-ponged back and forth or sent back and forth between the proponent, the secretariat, the scientific and technical body, and only at the end, the COP will decide on whether or not to adopt an area-based management tool. So what the treaty text says is that the text specifies that states can submit proposals either individually or collectively, and then have to submit this proposal to the secretariat. So here on the slide, you can see all the different requirements that the proposal has to include. So the proposal has to mention, for example, the geographical description of the area, what kind of human activities are taking place, what the goal is or the objective of the area-based management tool, such as marine protected areas. It also has to include a draft management plan, which includes proposed measures, monitoring, research, and review. And it has to provide information on existing area-based management tools that have been adopted by existing regional organizations, for example. So after submission to the Secretariat by the proponent, the Secretariat makes the proposal publicly available for everyone to see. And then the scientific and technical body provides an initial assessment or a preliminary review of the proposal. The scientific and technical body provides its feedback, and then the proponent will use this feedback to again work on their proposal. After it has worked on its proposal, there will be a round of consultations. So the treaty text provides a list of actors that will be invited to provide their opinion. So this includes, for example, other states that are not the proponents, but also civil society, indigenous peoples. There are quite a broad number of people that will be invited to for the consultation phase. Once the consultation phase has been concluded, then again, the proponents will look at this feedback and will work on its proposal. And only when it's considered it's done, when it's the final proposal, it will send it to the conference of the parties that will decide on whether or not to adopt the proposal. So in principle, the decision-making process of the conference of the parties is a decision by consensus. But fortunately, there is an option to use other voting rules, such as 2/3 majority voting. So it's 2/3 of the majority. There's a 2/3 majority vote on whether the consensus voting has been exhausted. And then there's a 2/3 majority vote on whether or not to adopt the proposal. I think this is a very positive development, because what we've seen with Kemlar in the Antarctic is that consensus voting sometimes also blocks the adoption of proposals. So what happens next after the proposal has been adopted is that it will enter into force 120 days after the COP meeting. Negotiators, they have decided to include an opt-out procedure in the text, which means basically that if a state does not support the area-based management tool, it can opt out, but it still has an obligation to cooperate. If it wants to opt out, there are 3 different reasons provided in the text that could suffice as a justification. Another thing to keep in mind in the ABMT process is the not undermining principle. So states have agreed that the BBNJ treaty cannot undermine existing regional or sectoral organizations that already have a mandate, for example, in areas beyond national jurisdiction. So there are also provisions in the part on ABMT on these scenarios. So for example, if existing organizations have adopted measures in areas beyond national jurisdiction, the COP may provide further recognition or support for such efforts and can take decisions on measures compatible with those adopted by existing organizations. If, for example, existing organizations have not adopted measures, the COP can make recommendations. So this is a way in which the not undermining principle has been respected in the text. Which I think is quite an advancement as well, because for a long time during the negotiations, it was not really clear what exactly the process would be or how to respect the not undermining principle. Then there are also provisions in the text on in the part on ABMTs on monitoring and review. So parties have an obligation to report to the COP on the implementation. Reports will be publicly available, and relevant existing organizations will be invited to provide information on the measures they have adopted. The scientific and technical body will monitor and periodically review ABMTs to assess their effectiveness and provide advice. Because of course, perhaps the situation changes as climate change, perhaps the ABMT has to be updated. So following the scientific and technical body review, the COP could update ABMTs if necessary. Then there's another provision in the text on emergency measures, such as in the case when a natural phenomenon or human-caused disaster has caused or is likely to cause serious or irreversible harm to marine biological diversity. So this could, for example, be in the case of an oil spill. So the details of this process still have to be further developed by the scientific and technical body, but it's good to have something in the text in case the ABMT regular process takes a long time. And then on implementation, it's important to also mention that in the case that, for example, a BBNJ state party does not agree with an ABMT, so has opted out, or is not member of a regional or sectoral organization that has a mandate over the area that's covered by the ABMT, this party is not discharged from the obligation to cooperate. So this is also an important safeguard as well to ensure that there cannot be certain states that do not participate at all in the process or do not cooperate. So what do we see as the main challenges in terms of implementation? So first of all, of course, we do have some provisions now in the text that explain how the BBNJ Treaty will not undermine existing organization, but the cooperation and coordination with existing global, regional, and sectoral bodies is still something, we will only know when implementing the treaty how this will work out and what kind of challenges will arise. So this is something that is not clear at this stage yet. We cannot say very much about this at the moment, but it can be a challenge. Also, the opt-out procedure in voting, we don't know how many states will make use of this, for example. It could be a concern if there are, for example, states that do have an economic interest, for example, in an area which is meant to be conserved. So this is something to keep in mind. Also in the text, there have been several safeguards, or the opt-out procedure is a little bit constrained. So for example, if a state party has decided to opt out, it has to renew its request every 3 years. And there are also other limits. There are only certain reasons that it can provide, for example, to opt out of this measure. So it's not completely that the state will not be involved. Then here on the slide, you can also see a publication that we've recently published on fast-tracking implementation of the BBNJ Treaty, in which we argue that a capacity needs assessment is really valuable to ensure that we can implement the BBNJ Treaty. And this is also relevant in the context of ABMTs. So the capacity building and the sharing of marine technology, this section, and the clearinghouse mechanism can already provide some assistance, for example, to developing states to ensure that they can implement ABMTs or this part of the treaty text, because one of the key problems is, in the end, in terms of marine protected areas, which we also see, of course, in exclusive economic zones and not only in ABNJ in the future. But the problem here is, of course, the capacity of states to ensure that if there's a vessel or a human activity or someone that is doing something illegally, whether there's enough resources and political will to do something about it. And this is especially tricky in areas beyond national jurisdiction, because the BBNJ Treaty will not create a global enforcement agency or a policing agency. So flag states remain responsible for the activities of the vessels that are registered to them. So they are responsible for enforcing regulations over vessels registered under its flag. And that's why they're also responsible for example, monitoring, control, and surveillance activities. That's why I think it's positive that a management plan is part of the requirements for a proposal for area-based management tools. And I think in the management plan, the monitoring, control, and surveillance capacity has to be specified. How many, for example, satellite technology do we have, or how many planes or observers, or what do we do in case we see some illegal human activity, who can do what, and who will finance this as well, because this is something that has not been discussed during the BBNJ negotiations. Also, flag states might already want to look at the enforcement regime and ensure that they have the authority and capacity to take action. And lastly, flag states might want to make sure that they have sufficient sanctions and inform national legal and administrative systems of what to do if they have some kind of evidence of illegal human activities in areas beyond national jurisdiction. When is this evidence valid in court, for example? So these are my preliminary thoughts, and I'm happy to answer any questions you have. Thank you very much.
Thank you very much, Claudia. And not surprisingly, we have already plenty of questions for you. First, plenty of questions regarding the articulations with the fisheries management, basically. So fisheries is not a specific pillar of the treaty, but fishing activities could be impacted by future MPAs. Is that correct? And how these articulations will be.
Yes, thank you, Julien. Indeed, fishing activities could be impacted by future MPAs in the high seas. So first of all, it's important to remind everyone that the general objective of the BBNJ Treaty is the conservation and sustainable use of marine biological diversity in the high seas. And the new process to create MPAs is basically a tool to realize this. These MPAs will aim to limit certain human activities. So this could include fishing activities, for example, as long as the proposal for the area-based management tool or the MPA does not undermine existing fishing organizations. And then it depends on, is there a relevant, for example, in the case of fishing, is there an RFMO that already has a mandate in areas beyond national jurisdiction? And if that's the case, it's this competent RFMO that will adopt the measures and not the BBNJ treaty or any BBNJ organ.
Thank you, Claudia. A lot of questions also around the enforcement and implementation perspective, with some mentioning the risk of paper parks due to a lack of monitoring, control, and surveillance in future ICES MPAs. So, Claudia, are there any tools, including technological, that could address this challenge?
Yes, indeed, it's a good question. And we at IDDRI have been following this topic of monitoring, control, and surveillance for a while. So in terms of the technology, there are tools that we can use. So there's a lot of satellite technology that's can be used to see what kind of activities vessels are doing in the areas beyond national jurisdiction. And organizations like Global Fishing Watch, for example, if you go to their website, you can see exactly what fishing vessels, for example, are doing in areas beyond national jurisdiction. This satellite technology gets cheaper and cheaper. And I think at a certain point in time, it will be possible that we have complete transparency and see where vessels are and what kind of activities they're doing. The question is more, we can do the monitoring, but what do we do in terms of enforcement? How do we ensure that there are really, for example, police vessels or some kind of way to ensure that there are sanctions that are being enforced against those conducting illegal activities?
Thanks. We have also some questions regarding existing marine protected areas that have been established in the ICES under the OSPAR umbrella, for instance. Is there a specific mechanisms or procedures for the recognition of these existing MPAs under the treaty?
Yeah, that's a very good question. I had a discussion with Glenn about this yesterday, and there is indeed a provision that recognizes these existing MPAs, but because there was some contention amongst the negotiators, they didn't want to specifically write down recognize, but it is included in the treaty texts that existing MPAs can be recognized. I can find a specific wording if someone wants this, but this is indeed envisioned.
Thanks. A clarification regarding the mechanism to propose marine protected areas. Can you confirm that only states can propose MPAs?
Yes, exactly. So it's only states that can be the proponents who can propose ABMTs or MPAs, and they can do this individually or collectively. But for example, other organizations like civil society, they cannot propose ABMTs or MPAs, but they do have a say in the process. For example, they can talk to states or yeah, they can be consulted as well during the process.
Okay, through the consultation mechanism. A difficult question, but let me ask it to you. Can MPAs be considered a tool to implement more equity in the ICES? And if so, how? Do you have any ideas about that? Thoughts?
Yeah, that's an interesting question, which I haven't thought about yet. But I think it can provide equity. If you think about that, areas beyond national jurisdiction are a global commons and are managed by all states together. So in the treaty, in the preamble, for example, it says that the objective of the BBNJ treaty as a whole is to ensure that there's still resources for a future generation and that states have to act as a steward. So I think this can help with the equity question.
Thank you. Again, a clarification on the procedures. Does the treaty provide for specific protection regime to the MPAs, or do the management plan have to be specified later in the process?
So as far as I understood, but please correct me if someone knows this better, but I have not seen any level of protection in the treaty text. So the answer is no, I think. It only provides a process to create ABMTs, but the level of protection will be clarified in the future as part of the management plan.
Yeah. Maybe a last question, and I will go back to Arne. The articulation, of course, this question is important. The articulations between this treaty and the current discussion on deep sea mining under the International Seabed Authority, and with somebody asking if deep sea mining, if we create marine protected areas, can deep sea mining be forbidden in this specific area?
Yeah, that's a good question. So first of all, it's important to clarify that BBNJ and deep seabed mining, they're ruled by different agreements and bodies. So it's not the same mechanism, and nothing is mentioned in the BBNJ treaty about deep seabed mining. However, the BBNJ treaty can have an impact on deep seabed mining. First of all, the BBNJ treaty applies to the area, the deep seabed beyond national jurisdiction, and the high seas. And in the context of MPAs, for example, BBNJ parties will be required to cooperate and coordinate with existing regional and sectoral organizations, such as the International Seabed Authority. And the ISA has already established areas of particular environmental interest. So this is something to keep in mind. And of course, the state parties to the BBNJ treaty also have to respect the general principles included in the BBNJ treaty, such as the precautionary principle and the ecosystem approach. So in any communication regarding the International Seabed Authority, that should be kept in mind.
Thank you very much. Very last question, Claudia, a very interesting one as well. Have some states already declared their willingness to propose MPAs in the ICs? Are there any proposal in the air?
Yeah, that's a good question. So what we've heard, I think it was maybe 2 years ago, is that Chile is very eager to be part of the first states to propose an MPA in areas beyond national jurisdiction. So I think the Southeast Pacific seems to be the region that is most ambitious in regards of the public statements regarding MPAs and ABNJ. But I have not seen any other propositions, but I can imagine that a lot of states were also waiting to hear what the procedure was before announcing their
I can on my side, yeah, I can also mention the Sargadon project funded by the French GEF with focusing on the Sargasso Sea and the Costa Rica thermal dome, which could be future MPAs declared under the agreement. Thank you very much, Claudia. Arne, are you back? There's still a lot of questions for you, so if you're back, yes. Super.
Back.
Excellent. A question regarding the articulation on DSI, specifically the articulations between the provision of the treaty and those under the CBD. Difficult one.
Yes. I just cannot. I cannot start my video, but I'm back. Thank you. On DSI, I wasn't sure how far I should open this debate here, but it's a very, very important issue because I think all actors are aware that most of the economic value lies in working with DSI, and thus also there is a need to regulate this to some extent. The CBD, I answered that in the written questions already. The CBD has a mandate to now come up with a mechanism to regulate DSI and the benefit sharing of DSI within 2 years. And so I expect that the BBNJ agreement will do very little in these 2 years to see what the outcome is of the CBD process, and then to hopefully harmonize and find a global multilateral mechanism. But otherwise, if the CBD gets blocked, BBNJ is an independent instrument that can also operate and develop a mechanism by itself.
Thanks, Arne. A clarification, I think, is needed on the legal status of marine genetic resources. Somebody asking the main differences between what has been adopted for MGR in the water column and the common heritage of mankind applicable to mineral resources in the deep sea.
Yes. So the mandate of the International Seabed Authority that operates with the common heritage of mankind relates to mineral resources. So genetic resources are the part of the organic resources. But if the organism is in the seabed, this falls under BBNJ. And if this organism is used for genetic research, the common heritage is in the BBNJ treaty, after all, but it is counterbalanced, let's say, by the explicit mention of the freedom to conduct marine scientific research. So I think it was important that there will be no sort of ISA style of access and management to such research, but the research remains open. But all these the resources and so forth are common heritage of humankind.
Thank you, Arne. Another question about the research organization. How was this treaty received by research organization, knowing that they will be impacted by new obligations?
Yeah, I think this is probably one of the most important questions, because these are the ones that have to comply with the regulations. And so far, I think I can say that it was received positively. It remains to be seen. So as I said earlier, I think research projects, especially specifically in Europe, are not worried at all, because most of what is discussed here and what is mentioned in the regulation is part of common research practice. If you run a research project in the EU or elsewhere, you need to submit most of these information and these reports anyways. What is new is the BBNJ's batch identifier, so it remains to be seen how this impacts the actual research practice. But overall, I think it's a positive framework that really reflects the current research practice.
Thanks a lot, Arne, for your explanation. By the way, I invite everyone to visit the excellent website of the Maripol Data Project you are part of, because it contains always very interesting and relevant information and analysis. Now let's move and explore environmental impact assessments with Glenn Wright. So please, Glenn, the floor is yours.
Thank you very much, Julien, and everyone for the questions. So I'm going to introduce a little bit of the background and the contents of the treaty on environmental impact assessments. And much like with protected areas and management tools, I'd say that the provisions build on what were already obligations in the Law of the Sea Convention, but build out new processes and make a way to coordinate with different bodies to fill in gaps and to try and sort of manage this articulation between different processes. I'll say at the outset, this is one of the longest parts, I think, in the treaty, because impact assessment is quite a technical process. And the treaty does go into quite some detail on those processes, but much remains for the COP and the scientific and technical body to work out later as well. Also, by way of introduction, I'll say that there were a large group of states, quite diverse states, during the negotiations that had a different vision, I guess, for this section. They conceived of it as being more of an internationalized process where the bodies of the treaty would be heavily implicated in the development of the assessments and also in the decision making. And in the end, that's not exactly how the consensus was reached. But the process does involve a lot of provisions for the scientific and technical body for notification and consultation. So to get to what is actually in the treaty, so the objectives for this section, as I said, are to operationalize what we already had in the Law of the Sea Convention, in particular by putting in place processes, setting thresholds and other requirements, and also to promote the use of impact assessments, including by adopting standards that can then be used and promoted in other bodies. So again, trying to bring some coherence to the various processes that currently take place. In terms of the scope of the treaty, there was a long discussion over the years between whether it is triggered by activities or impacts. So the treaty now envisages that any activity conducted beyond national jurisdiction should be subject to an assessment under this treaty. Where the activity takes place within national jurisdiction, but with potential impacts outside, a state can deal with this under their national assessment process, or they can go through the BBNJ process. But the idea is that they would be equivalent processes. In terms of what the assessment then looks like and how the process goes ahead, there is a tiered process. So this is something we see in a lot of national systems and also in the Antarctic treaty system, whereby there is an initial screening phase where the state assesses according to a relatively low threshold. So it's whether there's reason to believe there may be more than a minor or transitory effect. So that's to say that, if there's even a small suspicion there may be impacts, then you go to a second phase of scoping. And so scoping is a bit more involved, thinking about the different science that we have, trying to understand impacts, including cumulative impacts, so bringing in data from other activities, and really trying to understand what kinds of impacts may take place. Now, once that process has been done, there is then a higher threshold, which is the same as it is in the Law of the Sea Convention, which is may cause substantial pollution or significant harmful changes. And so if it may be that that threshold is reached, then a full impact assessment is then conducted, or an equivalent process under another body. And so throughout this process, there are various notifications given to different groups of states, depending on whether they may be impacted. There's notifications through the clearinghouse mechanism. There are opportunities for other states and for stakeholders to have input into the process. And there's requirements that the state respond to comments and explain how it has gone through the process and how these comments have been understood and incorporated, or why not. And of course, there'll be a large role here for the scientific and technical body in managing those interactions and sort of making them simpler for people to be able to see all in one place. I think we traditionally think of impact assessment, we picture a report, and it is true that there are reports that will be required, so including an impact assessment report, as well as reporting on an ongoing basis where the state is monitoring the activity and reporting on any significant changes or whether the assessment has to be updated. But more sort of contemporary practice within national jurisdictions, because most states have these processes nationally, is to view this process as a more adaptive management process that develops over time. So it's not just one final report, but it's also a way of bringing in new science, bringing in understanding. And I think we can see here that that will have a nice sort of synergy with the area-based management tools and with some of the institutional arrangements like a scientific body. In terms of implementation, who does what effectively? As I said, the state party itself will be responsible for conducting the process and making the final decision as to whether the activity should go ahead. So this remains a state-led process and not a sort of internationalized one with a global oversight. The Conference of the Party has a range of options available as well as some obligations. So it will develop a mechanism to collaborate with other bodies, in particular via its own scientific body. And it can also be requested by states to give advice on whether an activity can proceed. So even though the state conducts and makes the final decision, they can request advice from the Conference of the Parties and of course from the scientific body as well. The clearinghouse mechanism, which is shaping up to be quite a significant piece of institutional architecture for this agreement because it has many roles, but it will be part of this process of facilitating information access because the parties must submit a range of different things and they will go through the clearinghouse mechanism. And then finally, the scientific body, as I've said, has input, provides comments, is empowered to develop standards and guidelines that could be used for conducting impact assessments. And then it will consider the final reports, but it will consider them for the purposes of developing guidelines. So they're not making recommendations to states, nor are they deciding whether the activity takes place. but they are developing guidelines as a sort of background process. So in terms of initial reactions, I think it's a welcome update to the Law of the Sea Convention. You know, it keeps some of the language and the thresholds, but it strengthens that obligation, and it defines this tiered process that I think is flexible enough to cover, you know, cumulative impacts, but also future activities. A lot of the provisions are broad, so best available scientific information, traditional knowledge, includes a wide range of different potential impacts. So I think it's broad enough to cover quite a lot. And there's also a sort of hook there for strategic environmental assessments. So states could work through this agreement to assess, for example, a region that is seeing heavy development or a new activity that isn't clearly regulated by an existing organization. The process is also quite strong on consultation and transparency. But some sort of, you know, we'll see how it develops. But as I say, the decision is ultimately in the hands of states. And I think there'll also be some potentially difficult questions around how we interpret equivalent measures. So how do we know whether an impact assessment conducted under a fisheries organization is equivalent or up to a certain standard, and how will states negotiate that between them? So those are my initial thoughts. I hope that's been clear, as it can be quite a technical process. And I'd be happy to hear some of the questions that have been posed, if any.
Yeah, sure. Thank you very much. That was technical indeed, but extremely clear. So I have a few questions for you. First, does this treaty anticipate possible future uses of the ICs, such as renewable energy or offshore aquaculture, for instance?
So I think it's broad enough to incorporate those things. So it applies to biodiversity in general, and the kind of measures on equivalence assume that there is a body dealing with that. But of course, we can envisage potential future activities where there isn't a clear home for those activities, like offshore energy, but even potentially some novel fisheries, for example, you know, that potentially fall outside of the mandate of an existing organization, or where it's not being dealt with under that. And so a state, you know, proposing to do some new activity or some sort of test fishing could go via the BBNJ treaty to share the information and to do the impact assessment. And of course, that would definitely be the case in a situation where there isn't any regional organization to manage whatever the activity would be.
Thanks. A question from our dear colleague Jean-Pierre Gattuso. What are the implications for potential future carbon dioxide removal activities, ocean fertilization, ocean alkalinization? I think the same, probably, Glenn.
Yeah, hi Jean-Pierre. Yeah, it's a challenging one. I'm not an expert on these technologies. I'm just recently learning more about them myself. But yeah, I mean, if it has a potential impact on biodiversity according to these thresholds, then it would be subject to an impact assessment under this process. And so that would be a process that would be led by the state or the proponent. But ultimately would be shared, and there would be input from you know, from other stakeholders in other states.
Thanks, Glenn. Question on the decision-making process. First, the states make the final decision, but will the COP still verify if the decision is correct and acceptable, basically?
So I'd have to check the exact process, but I believe not. So I think this was part of the compromise, is that there's a lot of involvement, but the decision is ultimately, you know, down to the state. And if you think in a more sort of general law of the sea terminology, you know, to allow an international body to take that decision, a state would have to agree to have limited its sort of high seas freedoms, or given that power to another body. And, you know, some states were not comfortable with that. And so the Conference of the Parties and the scientific and technical body can make comments and provide input and support at various stages all along the whole process. But ultimately, you know, beyond the state asking for an opinion, it really is just down to the state to decide.
Okay. Are proposal for ABMTs in ABNG be subject to environmental impact assessment?
I think that may be a question that sort of mixes the two concepts, but I think what is there's a sort of a piece of truth there, which is that they're interlinked processes in the sense that the science will be relevant for both of those things. There'll be science that has been done in the context of other bodies and other regulations that will be useful for both impact assessment and for protected areas. So, you know, there's a big synergy between those two processes. I think perhaps at some point in the negotiations, there was a discussion about whether the threshold for an activity should be higher in particular areas or particular where tools have been designated. I'd have to check, but I believe that wasn't a large part of the final provisions, but I would have to check that.
Another question, will the environmental impact assessment will be made publicly available?
Yeah, all studies will be publicly available, as will, I believe, all the comments received and the responses that states are obliged to provide, you know, the justifications for decisions or for including or excluding certain propositions. So yeah, the idea is that this agreement, and particularly the clearinghouse, will provide a place where all of these you know, impact assessments can be collated.
And maybe a last question still about the decision making, because many participants identify the fact that at the end of the day, states will have the final words because there is no, say, international really mechanisms to control that. So basically, what's therefore the added value of this part of the treaty?
Yeah, it's a good question. Before sort of answering that, I mean, I think it's useful to sort of go one step back up and recognize that, you know, the state is the unit of international law in general. And so, you know, a state can only ever be bound by something it agreed to in any case. And so, you know, a state can either do that by pushing for certain provisions in the treaty that make it ratifiable, or they could simply choose not to join, or, you know, to do its own sort of process. So I think it's worth sort of recognizing that, in a sense, the decision is always down to the state, and the question of enforcement then becomes more about whether states are trusting each other and doing, you know, what they can to meet their obligations, which is, of course, an open question for all areas and all activities, not just in the ocean, but generally. So with that said, what's the added value? Of course, there will be really proactive states, I imagine, that will seek to use this process and seek to develop it. And I think it is a process that will develop over time. It's difficult to see exactly how that will look right now, and which activities will fall where. What equivalent processes will be determined. But I think the added value is that, I mean, it sets out a process. It involves a lot more stakeholders. It makes a lot of information public. And I think it provides a new stimulus for a provision of UNCLOS that has really never been utilized. As far as I've been able to find when researching this, no state has ever, I think, publicly expressed that it has done an impact assessment because of the UNCLOS provision and made it available. And that's because there's no process, there's no sort of pressure to really do that. Yeah, the obligation was there, but it wasn't clear where its home was. And so it has a home now and a process, and I hope that means it will develop and add value.
Thanks a lot, Glenn, for your analysis and to have replied to the question of the participants. Let's now focus on the last substantive part of the ICES treaty, probably one of the least known, the one dedicated to capacity building and transfer of marine technologies. Harriet, thanks again for accepting our invitation, and the floor is yours.
Thank you so much, Julien. Do you see my slides okay?
Perfectly.
Great. I'd like to thank the organisers for inviting me to join you today. My name is Dr. Harriet Harden-Davies. I'm the director of the Nippon Foundation Ocean Voices programme based at the University of Edinburgh. and I'm very happy to be here to share some initial reflections on capacity building and the transfer of marine technology that's been produced by myself and three of my colleagues, Vanessa Lopes, Julia Vega, and Mario Vieros. We're sharing some thoughts from legal and scientific perspectives on this very important part of the treaty. And I'm going to highlight three key messages in the next 10 minutes. The first is that capacity building and the transfer of marine technology is essential to enable all states to participate effectively and equitably. And this topic of equity is absolutely crucial in this agreement, and one that has not received as much attention as the environmental aspects of this agreement in recent media coverage. The second point I'm going to highlight is that this part of the agreement provides very important enabling mechanisms and institutional structures that give voice to developing countries and set a vision for long-term outcomes. And I'll illustrate how this is really a great addition to the existing framework. And thirdly, I'm going to briefly speak to some questions in need of further attention as efforts are turning towards ratification and implementation. But first, I want to paint you a picture of being in this room at the moment the gavel went down on capacity building and the transfer of marine technology, and invite you to imagine or recall, if you were there, this feeling of applause at midday on the final Friday of negotiations. This part of the agreement was the first over the finish line, but that doesn't mean it was without contention. Coming into the resumed fifth session of negotiations, there were open questions relating to issues such as definitions, intellectual property, and the strength of obligation for capacity building and the transfer of technology. And it's also important to keep in mind that these conversations take place against a backdrop of growing scrutiny on issues of equity, including in research partnerships, and calls to fully realize the vision put forward in the United Nations Convention on the Law of the Sea for the development and transfer of marine technology. And the result of the negotiations in relation to capacity building and transfer of marine technology really reflects these words that appear in the preamble, that this is essential for inclusive, effective, and equitable implementation of this agreement, where all states need each other in order to see this agreement realized and implemented in practice. So let me now briefly walk us through where you will find capacity building and transfer of marine technology in the agreement. And then I'll turn to give three examples as to why it is, in our assessment, a real achievement. So part 5 of the agreement is devoted to capacity building and the transfer of marine technology. It includes 7 articles that range from objectives, cooperation, modalities, types, monitoring and review, and the establishment of a body that I'll speak to in just a moment. But I'd also like to highlight that capacity building and the transfer of marine technology is very much a cross-cutting issue. And there's very important provisions relating to defining and operationalizing capacity building in all parts of the agreement. So let me now speak to 3 key ways that capacity building and the transfer of marine technology has really stepped forward through the process of these negotiations. So the first regards the what of capacity building and the transfer of marine technology. Under the agreement, it is considered to refer to the creation and enhancement of individual and institutional capabilities and capacity. So that range from individual people to organizations, from legal and regulatory types of capacity to science and technology. And these are set out in a second annex of the agreement, as well as Article 46. The agreement also provides a definition of technology in Article 1 that's not exhaustive, and it's suitably broad to encompass all types of technologies that are relevant for the conservation and sustainable use of biodiversity beyond national jurisdiction. And this was very important in giving effect to the provisions relating to capacity building in a way that will be effective for the agreement. But what's also important here is that these types of capacity building are not set in stone. The agreement provides a role for the Conference of the Parties, informed by a Capacity Building and Transfer of Marine Technology Committee, to review and provide guidance on the types of capacity building and transfer of technology in order to respond to evolving needs and technological progress. The second point I'd like to highlight relates to the why of capacity building and technology transfer. So if you look through the agreement, you'll note that capacity building is referenced in each part of the agreement. It refers for marine genetic resources to the importance of carrying out activities with respect to marine genetic resources and digital sequence information. For environmental impact assessments, one of the objectives is to prepare, conduct, and evaluate environmental impact assessments and strategic environmental assessments. And for area-based management tools, there's an objective relating to capacity building and transfer of marine technology for developing, implementing, monitoring, managing, and enforcing area-based management tools like protected areas. It's also useful to note that capacity building and technology transfer is also a vehicle for implementation in and of itself. In the context of genetic resources, it's a way of sharing benefits. And in the context of environmental impact assessments, there's a role for a roster of experts created under the scientific and technical body to help parties that have capacity constraints in relation to environmental impact assessment. And so when it comes to part 5 of the agreement, the objective of capacity building and technology transfer really emphasizes these issues of inclusiveness, equity, and effectiveness. And there's also a very important vision for capacity building that's been included in Article 45, which refers to further modalities for technology transfer. And it speaks to having a long-term vision of the importance of fully realizing technology development and transfer. And finally, I'd like to share some thoughts for a third point here about what the agreement says in terms of how capacity building will happen and who will be involved. So regarding the how, the agreement provides obligations to provide, for states to provide capacity building and the transfer of marine technology. Secondly, it sets out provisions regarding cooperation and modalities that give guiding approaches that are very important to articulate, like being transparent, participatory, gender responsive, and of course, responsive to the needs and priorities of states. There's also reference to tools like needs assessments to help inform capacity building. Thirdly, there's a role for a clearinghouse mechanism to match needs and opportunities and publicize requests for support. And fourthly, and crucially, there's provisions relating to funding for capacity building and transfer of technology. Regarding the who, there are, of course, obligations on states, not only to provide capacity building, but to submit reports on what capacity building and technology transfer is provided, and those reports will be publicly accessible. Secondly, there's a role for the establishment and a role for a capacity building and transfer of marine technology committee. And this is an important addition to the existing framework and one of the examples of a way that this agreement strengthens the current framework and catches up with existing arrangements under biodiversity and climate conventions. And thirdly, there's an important role for the Conference of the Parties to do things like review types of capacity building and undertake periodic reviews of the financial mechanism to assess the adequacy and effectiveness of financial resources for capacity building. So where to now? Well, although the agreement does provide a lot of very important provisions, as I've just very briefly outlined, there's also a few key questions that remain as we look ahead. So the first is that, of course, providing and supporting capacity building and technology transfer for widespread ratification and preparation for implementation. Secondly, the needs assessments are positioned to play a role. in the provision of capacity building. And there's an important time now to think about how to ensure that they are an enabling tool and mobilize support for countries to undertake them. Thirdly, monitoring and review mechanism in the agreement does represent a very important step forward, but it'll be key to find context-appropriate methods to measure the quality of capacity building and technology transfer initiatives and not only rely on quantity. Fourthly, there's some very important bodies established in the agreement that are very critical for capacity building and technology transfer. And we have a great opportunity now to think about how can we populate the pipeline of these pools of experts so that all the voices that should be there will be there. The clearinghouse mechanism is expected to play a key role, but there's certainly a need for further thought and discussion to really crystallize how this will work. And on the very important topic of funding, we've seen already discussion and some early commitments towards support for ratification. And now is a very important time to discuss how to scale up ambition and accessibility of funding for countries that need it, particularly in terms of support for this early ratification process and really getting ready for implementation. Thank you so much for inviting me to share these initial thoughts on the essential role of capacity building, what the agreement adds, and what some key questions might be in the coming weeks. And welcome any comments or questions. Thank you very much, Julianne.
Thank you, Harriet. Thank you very much. A few questions for you. First, do we already have examples of capacity building programs dedicated to the ICs?
Yes, indeed, there are. There are relevant initiatives that are underway, coordinated or undertaken by intergovernmental organizations, and also bilateral partnerships, including between research organizations. I think that what's really important is to recognize the language in the agreement about efficiency and avoiding duplication, and also to use this really critical time window to listen deeply to what works and what doesn't. An example of the type of thing that we're hearing and seeing is a declaration by the Alliance of Small Island States from June last year around capacity building, scientific research and technology transfer that really speaks to the need for modern thinking in equitable partnerships. And that could be very helpful as we think about ways of tying together and strengthening the existing actions that are underway.
Thanks, Harriet. Another question, is there a link between this part of the treaty on capacity building and more broadly the Sustainable Development Goals, including SDG 14?
Yes, indeed. To quote one of my colleagues from a small island state who said, we wear many hats. And if we think about the skills to interpret an environmental impact assessment, they can be applied in multiple different contexts. And we heard in the process of negotiation, I think, quite positive dialogue about the benefits of being able to think around synergies between areas beyond and areas within national jurisdiction, both in terms of human capacity, institutional capacity, and indeed technologies that are applicable, whether it's within or beyond the exclusive economic zone.
Thank you, Harriet. Thank you very much for your presentation and expertise on this last part of the treaty. We still have time for a very general question we received in the chat. So I will invite you all, the four of you, to reply to this question. First, that will be great to have a clarification on the next steps, adoption, ratification, condition for entry into force. Maybe Claudia, you would like to clarify that?
Yes, so the next steps are that the treaty will be officially adopted in New York at the General Assembly. So as I understood, that does not have to take long. It could be just a few hours of a meeting. And then there will be a signatory session, so states can sign the treaty officially. And then every state has to ratify the treaty and make sure that it enters into force at a national level. So in the treaty text, we see that there's a requirement for 60 ratifications to make it enter into force. And I now say it by heart, but please correct me. I think after 120 days after there are 60 ratifications, the treaty will officially enter into force.
Thank you, Claudia, for this clarification on the process. A few questions about the compliance committee that has been established under this treaty. I remember that Glenn, you worked on the compliance committee mechanism. So could you please tell us the added value of such a committee?
Yeah, I mean, obviously we have questions about compliance and enforcement. And as Claudia said before, you know, there's no international marine police that can enforce these things. And so because states have to agree on measures and on how they enforce, really it ends up being a facilitative process. And so it's very common in environmental treaties like this to have some form of compliance mechanism or compliance committee. And when we looked into this, you know, there are some treaties where there's maybe a stronger sort of not punitive, but coercive measures. But they tend to be in treaties where there's much more specific you know, issues going on, and they also usually have some sort of facilitative system as well. In this treaty, I think in line with the overall kind of tone of the treaty and the negotiations, it's very much a cooperative and facilitative mechanism, but it will provide a place where you know, states can go in a non-disputive, non-adversarial way that's transparent. And that can provide, you know, advice and support to states to implement the obligations. So it's not just compliance, but it's also implementation. So providing a space or a body that can respond to the needs of states as well. So linked to capacity building in a sense too.
Thank you. Another question: can this treaty help to regulate or to fight against illegal activities in the ICs? Ariette, Arne?
Just to pick up actually on where Glenn left off just there, sure. It's actually worth noting that, to speak to the question, that the development and strengthening of capacities and technological tools for monitoring, control and surveillance for biodiversity conservation is specifically mentioned in the capacity building part of the agreement. And I think that really reflects a recognition that this is a very crucial enabling tool. And it's a crucial enabling tool for detecting illegal activities in the high seas. And I think the fact it's specifically kind of called out in this part, which is such an important enabler, is at least a signal that it is one of the many, you know, priority areas that has been recognized in bringing this about.
Arne?
Yeah, I was asked this a couple of times on the MGR part as well. And I think in terms of the research practices and so forth, I think we can expect a really high compliance because it's in their interest and it represents the practices. I think, of course, it's very hard to design really hard monitoring institutions, but I think that the idea is also a bit that the clearinghouse mechanism, through collecting a lot of data and collecting a lot of reports and notifications, can have some sort of overview and highlight non-compliance and also call out non-compliant actors or countries, and that they then have to really justify in the COP their non-compliance. I think this is a good chance to really spotlight, put a spotlight on the non-compliance and call it out, and in this way ensure compliance.
Thank you, Arne. A broad question: can this treaty be considered positive for developing countries? Politically speaking, is this treaty a victory for developing countries? Difficult one. I think that we need to be a bit balanced, but don't know yet. What's your feeling about that?
I'm happy to share my feeling with the caveat that I recognize the limitations of my ability to think from a perspective. But from what I hear, having asked this question a lot, is that in many ways, this does represent a win for countries, including developing countries, in terms of the significant steps forward for capacity development and the transfer of marine technology, in terms of the elements of benefit sharing for marine genetic resources. And in terms of equity overall, there are some really important wins for equity, not just in terms of distributional aspects around monetary or benefit sharing or funding, but in terms of procedural aspects, in terms of voice for decision-making, recognition of traditional knowledge holders and local communities and indigenous peoples. And these have been hard-fought issues by many groups of developing countries and between combined groups from developing countries that I think all countries will benefit from in having a strong agreement. So in those ways, I think there are significant wins and positives. That's not to say that that there will not be things that, of course, I'm sure countries would have liked to see that haven't got there, but those are just some preliminary reflections from my side. Thank you.
Thank you, Harriet. Arne, you want to complete? Maybe, yeah. Please.
Yeah, I think a quick word, because I think
sure.
it's really Harriet explained it exactly right. I think this is, from different perspectives, is a really a victory for many developing countries, but also a very hard fought victory. And I think this can really be a milestone in ensuring equal access to research and databases and so forth, and also enabling countries to participate in these activities, which is necessary, I think, and especially for MGRs. I think this can be really read as a really a big step towards equitable sharing of these sorts of benefits from flowing from international waters. And so this is definitely a win for developing countries. Yes.
A clarification vis-à-vis the landlocked countries. We have some question about that. What are their rights, obligations? Can they participate? To what extent? Claudia or Glenn? Or
yeah, I can say something. So I also saw another question about whether all states can become a state party, and indeed all UN states can become a state party to the BBNJ Treaty. And landlocked countries have been mentioned several times in the text. So there is one provision on general principles and approaches that mentions acknowledgement of the special interests and needs of landlocked developing countries. And since ABNJ, areas beyond national jurisdiction, is a commons, landlocked countries can still be involved and take part.
Thank you, Claudia, for this clarification. And the last question for you, Glenn. I really like this question from Thiago. To what extent can the new COP system create a new momentum for interinstitutional cooperation between ocean-related intergovernmental organizations? That's the challenge, basically, Glenn, for the implementation, right?
Yeah, I could take the easy way out and express the momentum on a scale of 1 to 10, but perhaps to be a bit more accurate, I mean, I think it definitely creates some momentum. We see COPs from other treaties and processes being very well attended events, gathering media attention, gathering scientists and NGOs. Obviously, we don't know how this will develop. So there's that aspect. There's also the various powers and opportunities provided to the COP to develop standards, to add sort of new weight to old provisions, and to indeed bring developing countries more benefits. And not just, we refer always to developed and developing, but there's very few states that have high levels of capacity when it comes to the high seas. And so it's really essential to cooperate between all of these existing organizations. So yeah, I mean, that's the purpose of the treaty. I think a COP is an appropriate place to do that, supported by the different bodies. and hopefully in a few years' time, we'll have a functioning system that sort of brings more involvement to existing bodies, and complements what we already have. But indeed, with new protected areas for, in high seas areas under a treaty, stronger impact assessments, and hopefully more capacity building and sharing of benefits.
Thank you very much, Glenn. We have to close this webinar, and I'm going to switch back to French for final words. Et je voudrais commencer par remercier Arne, Ariette, Claudia et Glenn. Merci beaucoup pour avoir partagé votre expertise. Un grand merci à tous les quatre, c'était particulièrement intéressant. On n'a pas pu répondre à toutes les questions qui ont été posées, elles ont été nombreuses, mais on reste évidemment à votre disposition si vous souhaitez continuer à échanger avec nous sur le contenu du texte. Et pour votre information, on publiera aussi bientôt une analyse approfondie de ces différentes dispositions. Merci à vous tous et toutes pour votre participation. Je crois qu'on n'a jamais eu un webinaire Océan autant suivi qu'aujourd'hui. Donc merci à vous. Merci également aux traducteurs, Charles et Ali, à toute l'équipe communication de l'IDDRI et en particulier à Aurore et à Karine qui étaient aux manettes aujourd'hui. Merci encore et à très bientôt.